Can a spouse of the deceased who was left out of a will challenge a ladybird deed if that residence was their homestead? All right, first and foremost, there's no way to legally disinherit a spouse here in Florida. So you can't just cut your spouse out of the will. If you do that, your spouse is actually entitled to what's known as the elective share, and they can petition the court in order to get 30% of the elective estate. So you can't just leave them with nothing. They are entitled to something under the law. And as far as the homestead is concerned, and this is really important, if you try to execute a ladybird deed that makes it so that the property, say it's just titled in your name for whatever reason, but you are married and your spouse is living at the property with you, if you try to execute a deed giving it to someone else, a child, a friend, a sister, someone other than your spouse, that deed's actually going to be considered invalid. It's not going to work. You cannot disinherit your spouse. Your spouse has rights under law to continue living in the homestead for the rest of their life. So if they survive you, they're alive when you pass away, they get to live in the house for as long as they're alive. There's no way around that. That is their homestead right. And if you try to execute a deed to disinherit them or make it so that they can't stay in the home, Florida is not going to uphold that deed. It will be considered invalid.